Every Hindu is ecstatic about the 𝗟𝗏𝗏 judgment of the Madras High Court. The DMK was slapped so hard in the face yet again that its facial muscle almost turned numb because of the judicial bar that it experienced. So everybody wants to know the nuances and the substantive part of the judgment, which is 170 pages long. So I'll try to break down the nuances into 7 short points for the benefit of the viewers. Do share it widely. The first point is the failure of the state. It is ridiculous and hard to believe the fear of the mighty state, says the Honorable Division Bench of the Madras High Court, when they say that if a few people go atop a hill and light a lamp, it is going to cause disturbance in peace. The High Court says that it can only be done by the state, and I believe and we believe that the state will not stoop so low. No state will stoop so low to cause any disturbance of peace for its citizens. That simply says that nobody can cause disturbance of peace but the state. The next important point is a stinging remark on the district authorities. They say that the apprehension of the district administration is an imaginary ghost, which means that such an apprehension is not founded on legal basis or logical basis. And hence to say that it is going to cause stampede or disturbance in harmony among communities only exposes one of the two things. One, their incapacity to maintain law and order, or their unwillingness to bring in harmony between different communities. The second point is about maintainability. Why would a case of this nature be taken to the Madras High Court? So the High Court says that multiple articles which deal with fundamental rights, including Article 19, Article 25, and Article 29 of the Constitution, are dealt with in this case, and hence Article 226 of the Constitution comes into play, which simply goes on to say that the fundamental right of a citizen is being affected, and hence this is maintainable. The third point deals with whether this is a property of the temple and whether the Waqf has a locus in interfering into this. So the court goes on to say in para 112 that listen, this is called as the 𝗣𝗏𝗏, and the 𝗣𝗏𝗏 is being screened by the 𝗏, which simply goes on to say that this is a temple property and there is no locus for the Waqf to enter it. Also, the competent civil authority has already declared this particular 𝗣𝗏𝗏 to be a part of the Devasthanam. So there is no disputing the fact that this belongs to the temple. Point number 4 is about res judicata. You might wonder what it is. It's a legal term which simply means that if a particular issue has been already decided by courts, there is no point in relitigating about it. In this particular case, the Honorable Court says that by quoting various judicial precedents from para 111 to para 119 in various cases, that various issues have been gone into in 𝗟𝗏𝗏 hill, but the concept and the question of whether the lamp can be lit atop the 𝗣𝗏𝗏 has not been ventured into and has not reached finality, and hence res judicata does not apply in this particular case. And also they cite this case of Kantaru Rajivaru versus Indian Young Lawyers Association, where it simply states that res judicata will not be a bar when the matter is of public importance. So you can't quote res judicata and escape judicial scrutiny. Point number 5 is interestingly about Agama Sastra, and this time it's not the Hindus who bring in Agama Sastra, but the temple authorities or the government bring in Agama Sastra and say there is a custom of lighting the lamp elsewhere and it's against Agama Sastra to light it on the lamp. The court actually breaks down this myth and says there is no mention of any of this in Agama Sastra, and hence there is no bar on anybody lighting this lamp atop the 𝗣𝗏𝗏. So the DMK propaganda gets shattered this time even by using the Agama Sastra. Point number 6 deals with the very serious question whether this is the 𝗣𝗏𝗏 or it's a survey stone, as quoted by many DMK members. Here, the court relies on the Great Trigonometrical Survey of India Volume 2 by Colonel J.T. Walker, who was the Survey General of India back then. This survey clearly points out that the 𝗣𝗏𝗏 is not the survey stone as claimed by many. In fact, to quote the judges verbatim, they say, this eliminates the calculated campaign by some of the private individuals that pillar is only a markstone left behind the survey department of the British Raj. Para 135. The last point is about the violation of principles of natural justice. If you wonder what it is, it's about giving a fair opportunity to both sides to be heard. You can't decide a case without hearing both sides. They said and alleged that the Waqf was not given enough time to represent their side of the details. But in this case, the court clearly distinguishes between a civil court as well as a writ court. In a writ court, the documents can be given at any stage, and they go on to say that we have entertained all pleas at all lengths, and hence there is no need for somebody to feel aggrieved about this. So the principle of natural justice is not violated. That pretty much sums up the 170-page judgment in just 7 important points. Do follow me for more updates. Thank you. Jai Hind.